Hi, Darin Mangum here, Securities attorney. Um, if you've watched any of my videos over the years, you've obviously heard me talk till I'm blue in the face about the necessity of full disclosure, the necessity of a private placement memorandum whenever you're offering and selling securities of any kind, cryptocurrency, real estate, stocks, promissory notes, any of that, you know. It's all securities. And oftentimes, we get into conversations with clients. Well, are these really securities? Are they not? I mean, you know, you can watch a lot of my other videos where I talk about what is a security and how do you determine that. But obviously, the necessity of a private placement memorandum is, I can't emphasize it enough. And again, that sounds like self-promotion because that's obviously how we make our living. But every once in a while it really hits home that, hey, this is really critical stuff. Um, for the most part, our law firm, we handle transactional work, putting documents together, but we also do SEC defense work as well, Securities and Exchange Commission, administrative proceedings, state securities enforcement actions. We do a fair amount of defense work as well. It's not my favorite thing because it's not pretty. Usually we're trying to, preventative medicine, to use an analogy, is always better than open heart surgery, right? And so oftentimes when we do SEC defense work, it's like it gets pretty bloody and ugly, right? And not always are we able to have a successful outcome. Sometimes, we're obviously able to have a successful outcome, get the SEC off our clients' back, point them in another direction, and get the investigation concluded without any problems. Every once in a while, though, it takes a nasty turn. Years ago, I think I posted a video of a story of a case where we had a client that had raised capital without a private placement memorandum and was facing criminal charges as a result. And we were obviously able to settle that case. But just a few weeks ago, we have a current client. I'm not going to reveal who it is, obviously, but we were handling a state securities administrative matter, and we were this close to working out a settlement where the client would neither admit nor deny the allegations, but they were going to settle and have it essentially be done. Obviously, all this is in a civil proceeding. And then all of a sudden, out of the blue, it takes a nasty turn. And so while we're negotiating with the state securities division on one hand, the state attorney general decided on their own to file a criminal case against our client on the same set of facts. I know that sounds like double jeopardy. It sounds like but two swings of the bat. But again, they're two totally separate matters. One is a civil proceeding, and then one is a criminal case. And it's like, holy cow. So our client was all of a sudden charged out of left field with, on the same exact facts, under 3 counts of felony securities fraud. And when we read the complaint, it's exactly the same facts. And the key factor is that they're claiming that the client did not provide full disclosure. And I'll read you the criminal charge. 1, 2, 3 counts of securities fraud for what? Not, the defendant did not disclose information typically provided in an offering circular or prospectus concerning the business activities, including but not limited to compensation of directors and officers, conflicts of interest, risk factors, suitability factors, and whether the securities offered were registered or exempt from registration. So these are the things that a private placement memorandum does is it protects you against, obviously, a civil proceeding, but even a criminal charge, and so so now, and then the case, and, it's remains to be seen whether we're going to now, again, we don't typically handle criminal cases, but it's so close and all the facts are the same that we're obviously now we're trying to settle a criminal complaint at the same time we're settling the securities matter. Now, obviously, that's, hopefully we're going to be able to be successful in doing that. But it just, again, every once in a while it just hits home like, okay, we thought that our client had it, and we were able to get it done. I mean, obviously he made the mistake of not using a private placement memorandum in the first place, and the deal didn't go well. The project didn't go well. And so now he's faced with not only a securities violation on the civil side, but also criminal felony charges. I mean, it's serious business. And so, I don't care if you hire me, our firm, to do your private placement memorandum, but you got to get one. I mean, get one. I mean, even if you have to, put it on a credit card, whatever, you just have to get that documentation in. And again, that helps you sleep at night, that know that it's done right. Obviously, you don't want to pile of junk either. You don't want to go to some chop shop. Oh, give me a private placement memorandum. Oh, $5,000. Here you go. Boom, done. And not worry about it. I mean, you definitely want to use seasoned securities counsel. It's that serious. I mean, it's just that serious. So anyway, hopefully it would be us, but anyway, it doesn't matter. You just got to get it done, get a securities attorney, and do it right. And so anyway, hopefully these videos are helpful. Use my AirPods today. Hopefully a little better sound quality. If we can certainly help you, feel free to reach out. I'll leave my contact information in the feed below. But please feel free to comment. If you like this content, please like us. Please subscribe for more content, and we'll see you on the next video. Thank you.